1972, the California Mandela Act on solitary confinement. Despite the volumes of research that shows how solitary confinement causes deep psychological and physical harm, it remains common in jails, prisons, detention centers, and facilities across California. In fact, the current consensus among mental health experts, human rights organizations, and the United Nations is that prolonged solitary confinement amounts to torture. In 2016, the National Commission on Correctional Health Care stated that a period of confinement beyond 15 consecutive days is inhumane, degrading treatment, and harmful to individuals' health. The lack of human contact and endless monotony causes deep depression, paranoia, and some even suffer hallucinations. Others experience large fluctuations in weight and chronic pain. And due to its extremely restrictive conditions, chronic health conditions either go untreated or are mistreated. AB 2632 provides a clear definition of what constitutes solitary confinement across all facilities in California and imposes strict limits on how it can be used. Additionally, this bill will prohibit the use of solitary confinement for vulnerable populations such as pregnant women and those with intellectual disabilities. To state the obvious, people who need specialized care should not be locked in a room the size of a king-size bed without access to the services they need. AB 2632 also provides important protections for those placed in solitary confinement. An example, current regulations allow the use of food and nutrition as an additional lever of punishment for confined individuals. This bill disallows that. Many times we like to boast that as California goes, so goes the nation, but we are behind in setting clear standards on the use of solitary confinement. Several states, including New York and Colorado, have already taken this critical step. California must join these states and the international community to set clear standards and limits on the use of solitary confinement. This begins by recognizing that prolonged solitary confinement is torture, and setting uniform and consistent limits on how solitary confinement is used is in all detention facilities. Here with me to testify in support of AB 2632 is Eric Harris with the Disability Rights California and Kevin McCarty, who will speak to the impact solitary confinement has had on his life. Hamed Yazan Panah is also here to answer technical questions on the bill. I respectfully ask for your aye vote.
Okay, gentlemen, you have 5 minutes, and whatever way you want to break it up is fine.
Thank you. Good morning, Chair and members. My name is Eric Harris, and I am the Director of Public Policy at Disability Rights California, a statewide nonprofit protection and advocacy organization that advocates on behalf of all people with disabilities in the state. We are part of a coalition of proud co-sponsors of AB 2632. We work in jails, juvenile facilities, and detention centers to improve conditions, eliminate unnecessary isolation and segregation, and secure adequate medical and mental health treatment for those who are incarcerated. Solitary confinement is torture and a priority issue for DRC because of its harmful impact on disabled people who as a group are disproportionately subject to its use. We've litigated, obtained consent decrees with jails, and negotiated with immigration detention operators to limit its use. Most recently, we served on the Executive Steering Committee and working groups of the Board and State Community Corrections for the Title 15 Jails regulation revision to limit solitary confinement, but were unable to get the necessary reforms through that process. We have concluded that California needs a statewide, comprehensive legislative solution to end the solitary confinement of people with disabilities in jails, prisons, and immigration detention centers. Solitary confinement is a practice that does not rehabilitate but causes harm, especially to vulnerable populations. Solitary confinement is not an effective tool to manage violence in carceral settings. Rather, solitary confinement exacerbates these issues. Research shows that solitary confinement does not make jails or prisons safer, nor does it improve public safety outcomes, because exposure to solitary confinement has been proven to increase recidivism in some cases. The co-sponsors of this bill also view solitary confinement as a racial justice issue. Solitary confinement is most often used against people of color, especially Black and Latinx people. Although these statistics are not released to the public, researchers estimate that between 85 and 90% of people in solitary confinement are people of color. We need AB 2632, a bill that would ban solitary confinement for vulnerable populations such as individuals with disabilities, pregnant women, youth, and the elderly, prohibit long-term solitary segregated confinement by limiting the time spent in confinement to not more than 15 consecutive days or 40 days in a 180-day period, and require facilities to keep clear records of the use of solitary confinement in order to provide public transparency and accountability. The co-sponsors of this bill have had conversations with law enforcement and believe that we can come to a common ground on this bill. California would join other states like New York and Colorado, which have passed similar bills. AB 2632 would help California set clear standards and limits on the use of solitary confinement in jails, prisons, and detention centers. Thank you, and we request your aye vote.
Thank you. Okay.
Greetings, Honorable Chair and members. My name is Kevin McCarthy. I'm an undergraduate of legal studies and a member of the Underground Scholars at UC Berkeley. I spent a total of 22 years incarcerated and roughly 12 years in solitary confinement, including 2 years in solitary confinement as a juvenile. My first experience of solitary confinement took place when I was sent to the California Youth Authority. I needed treatment for addiction, but instead was given solitary confinement. Once a week, we were given one novel, 5 pieces of paper, and a pencil. Talking to our neighbors while in our cells was prohibited. We could only talk to other people when we were given 1 hour outside in the exercise cage. Usually I finished my weekly novel in a couple of days and became so desperate to talk and hear sound that I would ask myself questions and then respond out loud. I would also recite every memory that I could remember since birth just as a way to get my mind to do something. Sometimes I would just sit there and cry out of frustration. I would go on to spend a total of 23 months in solitary confinement before I was paroled, but not before I saw 2 people commit suicide in solitary and many others make suicide attempts. Once I was out, I felt so much anger and animosity, especially towards figures of authority. I avoided people and did not like talking to anyone. Solitary confinement is a vicious assault upon one's psyche and soul. It is a form of spiritual, emotional, and psychological torture. How can we prohibit physical violence under the 8th Amendment, but not stop violence against the mind? I would have preferred a physical beating in lieu of solitary confinement. Bruises and cuts on my body heal, but the wounds in my mind and soul have only become infected and continue to harm me. When I was in solitary, the guards' favorite response was, "They don't make the law, they just follow it." This legislature makes the law and has the opportunity to stop torture and save lives through this bill. I stand before you today as a testament to the horrors of solitary confinement and also as proof that people can change their lives. There is nothing that the state can do to restore me and other victims of solitary confinement, but this legislature can protect future generations from experiencing this permanent harm. I urge this committee to give a yes vote. Thank you.
Thank you. Are there any other witnesses in support?